We'll just give it a couple more minutes and we'll get started.
And by the way, Kathy, if depending on the size of the group, if you prefer and if people want to be visible, if they have questions, I don't particularly care, but I leave that to you, and we should have talked about it before people started jumping on, but whatever.
You know what we can we can ask them to unmute if they have questions.
Sure, whatever they feel like doing.
Okay, perfect.
Totally fine, but I won't speak for Brian. I'm easy. I'm sure he is.
Okay, no worries. You know what, we'll go ahead and get started, and I'll just let people in as they come. Welcome everyone, and thank you for coming. I just want to thank Pettit, Cohn, and Gracia, Lutz, and Dolan for being here today. We're going to talk about the California Consumer Privacy Act, which went into effect on January 1st, 2020. And it will be in force starting July 1st. So they are going to be talking to us about what we can do and how to get ready for it. I would like to introduce Ryan Nell. He's a shareholder and leader at the law firm, and he represents California employers statewide in both counseling and comprehensive litigation support. I want to welcome Ryan Nell. Ryan, thank you. I'm going to turn it over to you.
Great. Thank you, Kathy. Let me share my screen here and try not to make a mistake. I think. Is this the right way? Does it look right?
That's the right way.
All right. Okay, great. Thank you, Kathy. As Kathy mentioned, my name is Ryan Nell. I'll be presenting this afternoon with my colleague, Bron D'Angelo. And what we want to do today is we want to talk to you. I need to move my cursor around, sorry. What we want to do today is we want to talk to you about the California Consumer Privacy Act. It's something that hopefully has been on your radar as a business owner, as a business owner, business person here in California. If it's not, in one sense, it's a little bit too late because it's already come into effect. But on the other hand, it only came into effect about 3 weeks ago. Came into effect in January, but penalty phase just started about 3 weeks ago. So hopefully it's not too late for you to make sure that your company is in compliance. As Kathy mentioned, Bron and I bring kind of different experiences, different backgrounds to the presentation here. So we have our bios here on the pages, and you can read them and go through that. But really the broad strokes of it are, I predominantly practice employment law. That means that I deal with representing companies that have various employment issues. That could be anything from wage and hour law to harassment, retaliation, discrimination claims against them. We defend those. But it also means that I do quite a bit of counseling work, and in doing so, work with companies on how best to create policies to make sure that they are staying on the right side of the law here in California. I don't know if you can see over my shoulder, the book of employment laws here in California is about this thick. You got to follow every one of them to the word. That's what keeps me in a job. But because I work with clients on counseling, one of the kind of tangents that we've seen in the last year or so has been CCPA. It's something that's been on the books since 2018 was when it got passed. And since then, we've been getting a lot of questions. And now we're finally at the point where the rubber meets the road. So I've been talking about it from a counseling perspective, which Bron can do as well. But Bron wants to talk, or is going to talk to you today, a little more about the litigation side. Bron is an experienced litigator, trial advocate. So that's what he does. He deals with this stuff in the courtroom even more so than I do. And so he sees these things and then can kind of foretell what we're going to see in terms of litigation, what we're already seeing, and what we can expect to see both from the Attorney General and on the private side. And as you'll soon learn, the penalties for failing to comply with the CCPA are quite steep. So why are we here? That's the big question, right? And it's because the world has placed a significant focus on privacy. If you're familiar with the GDPR, that was passed in the European Union, I believe in 2013, maybe a year or two off on that. But it was for the European Union and protected privacy rights. And for companies that did business in Europe or had ties to the European Union, there may have been some compliance issues there. But now this CCPA brings that to the United States. All of us here, since this is the Carlsbad Chamber of Commerce, I can pretty safely assume we're based here in the state of California, or at the very least do business here. And so it's very at home for us, but this actually applies nationwide and really to anywhere where companies do business in California. By the nature of interstate commerce, where you have your place of business doesn't particularly matter, because if you have it somewhere in the United States, there's a good chance you're doing business in California. So for us here that are based in California, of course, it's very close to home. There are other states that are looking at passing similar laws. I know Washington, Illinois, a few other states either have them that are being drafted or already on the books. And that's something that we're going to want to keep in mind as we progress through the years and through the election cycles and through the voting cycles, because not only will we have to stay in line with California law, if we're a company that does business generally, particularly on the internet, we may be dipping our toes into other states. Illinois is a big state. They have a lot of people. They may be visiting our website and we may need to follow that. So we're going to keep an eye on that. But today we're going to talk about the CCPA. So what generally is it? It was passed back in June of 2018. An interesting factoid, I suppose, about the CCPA is that it actually was written in 7 days, which is an extremely short amount of time. And the reason for that, or at least what we believe to be the reason for that, is that there was going to be a ballot initiative in the state that was going to be a lot broader and even more protective. And tech companies really didn't like it. They thought that it might be overbroad. And so what the legislature did is it passed the statute as it was. And so it wrote it quickly, passed it before the more onerous one could get put on the ballot, potentially get passed, and then place even more restrictions on California companies. On one hand, perhaps that's a good thing. It's a little less onerous. On the other, created a bit of a messy bill. There's some issues that came up in the drafting. There's some contradictions. In broad strokes, we know what it says, but on the little nitty-gritty nuance, there are some issues. Now, my purpose today isn't to go totally into those nuances. I don't know exactly what each of your businesses are, and a lot of things may not apply. So if you have questions specific to your industry, ask us later, or we can ask their question asking functions here. Give us a call, do whatever you'd like, and we can follow up more specifically. But what I want to do today is spend about 20 minutes or so, a bit more, talking generally about CCPA and how it applies in broad strokes and what you need to do to stay in line with the laws before Bron then comes on and talks about the severe penalties if you are not in compliance with those. So as I mentioned earlier, the effective date of the law was January 1st, 2020. That was when it came into place. July 1st, 2020 is when the Attorney General was able to start enforcing it. Now, Bron will tell you about the 30-day period in which things can be fixed. So we haven't really seen much yet, but the Attorney General, we can safely assume, is starting to sniff around because they can. And while we thought that it's possible that COVID may have had an impact on that, all signs are a go. Things are in place now as they were intended, absent everything that's changed in the world. Things to keep in mind: for one, this applies to a natural person. So that means an actual person, as opposed to what we would call a legal person, which could potentially involve organizations or entities. This is actual, natural people like you and like me, and their personal private information. It's also, when it comes from, it only applies specifically to businesses that collect the personal data directly from consumers. Now, this is a bit of a nuance if you're familiar with the GDPR. The GDPR is a bit more broad in that sense, but for California's purposes, it's where we're collecting it directly. Now, who applies? So what are the categories that need to be met for someone or for an organization, I should say, to fall under the CCPA? Well, first, it needs to be a for-profit organization, and it needs to do two things in a conjunctive sense, and then one of three things in a disjunctive sense. So conjunctive needs to be a for-profit business that collects the personal information of its consumers. That's one. And it needs to conduct any form of business in California, including, importantly, that e-commerce. So if you're based in Texas, but you do business here, you count. If those two criteria are met, then you go down to the disjunctive list where one of the following three need to be met. There either needs to be gross revenue of $25 million or more, You need to collect the personal data of 50,000 or more consumers, devices, or households, or you need to obtain half of your yearly revenue by selling personal data. The last of the three, you're almost certainly going to know whether or not that's the case, because that's the business that you're in, is you collect data and you sell it. The first one, you probably know what your top line revenue is, so that's pretty easy. The collecting personal data of 50,000 or more consumers, devices, or households, you should have access to those sorts of metrics, but that's very often the category that's capturing employers. You may not do $25 million in business. You may not be in the business of collecting data, but you may access or have 50,000 people or devices or households that are providing you with data. So you're going to want to make sure that if any of those are satisfied, that you're complying with the CCPA. So I view this all now, when you look at the data you're collecting, it's the who, what, where, when, why, and how, right? It doesn't make quite as much sense in this order, but it has that nice flow to it. So let's talk about it. First, from whom do you collect? There are a few questions that are going to come up, and we'll talk about them in a minute about ages. For the most part, I'm going to be talking about folks assuming that they're 16 or above. If an individual who accesses your website or gets their personal information saved is between the ages of 13 or 16, they can opt in. And if they're below 13, they're presumed to opt out unless a parent or guardian opts in for them. That's a nuance that probably doesn't matter for most of you, but it's something to keep in mind. If it does, if you have a company that for whatever reason particularly caters, whether on purpose or just by happenstance, to folks that are on that line age-wise, you'll want to look into it a little more and make sure that you're complying. But for most companies, it's not a huge distinction. What do you collect? It's personal information. So there's a list. And if you look, there are a few things that have been published on this. There's the CCPA is the law. That's the law that was passed. It's section 1798.1 of the California Civil Code et sec. So it's a bunch of sections after that. But then there's also what's called the California Consumer Privacy Act regulation. And what that was, and we've got reference in this, but it's 999.300 et sec. So it's a different section of the Civil Code. It was put out by the Attorney General, and it explains the law. There were a few iterations of this that were put out, the most recent of which was back in mid to late June. I've got it somewhere here. I can show you. It's 30 or so pages long. And it's effectively the Attorney General explaining the law. As I mentioned, when it was written back in 2018 and passed quickly in 7 days, kind of had soft edges to it. And so we've needed to get some explanation, in this case, from the Attorney General, which is the very body that would be prosecuting claims for violations, or at least the non-private claims, explaining what they mean by some of these things and what the guidelines are. So I'm going to go through some of those, but it's something that you may want to take a look at as well. It's 30 pages. It's a little dense, but it's written in an actually pretty accessible way. So take a look if this is something that your company is bound by. So in terms of what personal information is collected, there's a long list of what it could be. It's not general, just the name, top line type stuff, but it's more specific information. There are lots of different things that could be social security numbers, that could be passports, that could be things tied to your email if it's a little bit more than just basic stuff. Protected characteristics, things that may go to your personality traits, that can include hair color, eye color, things like that. The idea behind all of this, as you may or may not know, is that companies are able to extrapolate a lot from what they can learn from you. And they've got algorithms that can figure out all about you. And so that type of information that they put in there, that's the data that's being collected. And in this case, is being protected. When are you going to implement the policies? Now, yesterday, 3 weeks ago, hopefully. Well, hopefully even before that. But now's the time where the AG can come in and really do something about it. So if you haven't thought about the CCPA and your company is one to which it applies, take action now. Start thinking about it. Finish this webinar and start thinking about it. If you've already done so, good. Where do you store the data? That's a more internal thing. You need to think about that. Are you storing it in-house? Are you making sure that there are appropriate protections that are put in place to keep things as secure as they need to be? Bron's going to talk to you about the penalties for failing to do so appropriately. So make sure that you're doing what's necessary and taking appropriate precautions to keep things safe. Why are you gathering the data? That's an important question, right? As I haven't said directly, but you've probably already gathered or probably already know, this is very often is when you go onto a website these days and you see on the bottom, accept cookies or do not sell my information. This is what we're talking about. And it's because those companies are gathering data on the people that visit their websites. So if you go to, pick whatever, you go to Nike.com, by accepting that, which we by and large all do, Nike's going to have some access to our information. Now, if you click on the fine print of that, you can actually go and look, and there's actually going to be an anecdote. I don't know exactly what Nike says, but there's going to be a long list of information that they gather, and they need to make you aware of that. But they're doing it for a reason, because that data to them is important. It helps them drive what they do. They may be doing something with it. Certain companies are selling it, or they're making use of it, or they're sharing information in ways that can help them or help their business. But for your business, you want to think about why. Why are you collecting this data? Because having it, if you're not going to use it, may not be what you want to do. So think about that and make sure you're kind of doing it the right way and you have a why. And then how do you collect it? What is your manner by which you're doing that? That all kind of falls into place from the front end. If you're doing it and what you're gathering, how do you collect it? For the most part, this is over the internet, but it also can be in different ways. And the regulations tell us what to do if it's, for example, over the phone, if it's on a mobile application, which is slightly different. There are different things that you need to do and different processes that you need to follow. Okay. First step for compliance, you need to create a disclosure. That's the disclosure that you see down at the bottom of the page. And that the statutes tell us that it needs to be made at or before the time of data collection. Now, I'm going to talk a little bit about this, and I'm going to say it, I think, on the next slide. You want to be wary of these one-size-fits-all disclosures. What you're not going to see on our presentation is, a generic example, because that's not really the name of the game here. That's not us trying to sell you one, not at all. It's us saying you need to put some thought into what this is. Just because it works for Nike or works for whatever XYZ company doesn't mean it applies to you. It's an interesting exercise to take a look at some of them, quite frankly. If you click on that more information tab and see what they say, it can be helpful. So what needs to be in the disclosure? One, it needs to be plain, straightforward language. That caveat is in just about every portion of these regulations. It keeps saying plain, straightforward language. It's not legalese. It's not buried in small format, because it needs to be in a format that draws your attention. You need your consumers to know what they're doing. They need to see it at the bottom of that page or at the top of the page if it's online, wherever it is, and it needs to be abundantly clear that this is the information that they're trying to access. It also needs to be available in languages in which the business ordinarily does its business. For example, I have a client that works predominantly with Filipino clients. Because of that, they needed to have it not just in English, but in Tagalog, because that's what many of their, not their employees, their consumers or customers use. It's boundless, right? If you have customers that speak Spanish, you need to have it in Spanish. And it needs to be reasonably accessible to consumers with with disabilities, An interesting point with this, and it's a bit of an aside, but we're seeing more and more of these cases lately. If you're a business owner, you've probably dealt at some point with ADA claims. The ADA claim that we're seeing with increasing frequency now, and we deal with them, Brian and I do quite a bit with our clients, because they'll get hit with these, and they're usually smaller cases and just more things that we have to try to make go away. It's traditionally the if you're a hotel, you don't have the right ramps. If you're whatever the case may be, parking lot issues. The newest thing is access to websites for the visually impaired. That is to say that your website is not able to be read by the programs that read for people who are visually impaired, and the lawsuits like that are popping up like crazy. So that's a complete aside, but something to keep in mind. And in this case, you want to make sure, as with the rest of your website, that the disclosure is available and accessible to folks with disabilities, whatever the disability may be that may prevent them from accessing, okay? What's in the disclosure? You need to talk about the categories that are being collected. So what is it that you're gathering of this personal information? And the list is long of what it could be, so know what you're gathering and disclose it. You need to say why. What are the purposes for this? And you need to be pretty transparent with it. If the purpose that you have is that you're going to gather this and you're going to put it all together and you're going to sell that packet so that a website knows what ad to put on your next website, well, you need to share that. There are ways to say it in the appropriate way, not, hey, we're going to sell your stuff, but you need to say what you're doing with it. You also need to have, if there's a sale of personal information, there needs to be an option that says, do not sell my personal information or do not sell my info. I'm sure you've all seen this. In all likelihood, not many of us are actually clicking that, but you can. And if you do, you have the right to do so, okay? And as a company, you have to include that. And there has to be a link to the privacy policy, okay? We're going to talk about the privacy policy in just a minute here. Okay. Excuse me. Where is the disclosure made? As I mentioned, for the most part, it's going to be online, so it just needs to be a conspicuous link. But there are things to keep in mind for if it's a mobile application, if it's offline, if it's via telephone. The regulations tell us exactly what we need to do to make sure that's met. Again, for the most part, we're looking at online. And I already told you, be wary of those one-size-fits-all. Just because it works for one organization that does things one way, doesn't mean that it works for you, particularly as we talked about. If you have to say how you're going to use that, the way one company may choose to use information may be entirely different from the way you choose to use it. And you don't want to run into a situation where you're, in this case, likely unintentionally misleading folks. So keep that in mind as you're creating your disclosure. And then update it. The law is changing. Both the CCPA is likely to change as we, round out the edges and we figure out what we want it to look like now that it's been drafted. We may find some issues in how it's enacted and the like. And as other states pass legislation, we're going to need to make sure we're following that too. So what you don't want to do is if you sat there on January 1st of this year and you said, okay, we put our policy in place, it works, thank you very much, we're done. And then set it and forget it, that's a problem. That will be okay for some period of time, but eventually something is going to change and eventually it's going to run out. This is analogous in my employment practice. Very often see policies that are out of date, right? And you can imagine that when I get a lawsuit, one of the first things I do is I look at the policy, right? I say, okay, send me your employee handbook. And I can't tell you how many times I open it up and down at the bottom it says drafted January 2009. I go, uh-oh, because that means that someone did that and checked the box. And then for the last 10, 11 years, they've said, hey, we've got that handbook, we're done, let's move on. Or for individual policies, drug policies, things that may have changed over the years in practice, they're not changed. This disclosure is just the same way. It may be newer and it may take a little more time to get stale, but you want to make sure you're keeping things fresh. And as a matter of practice, if you're looking at it every year when you're looking at your handbook, that's a great idea. Okay. Create the privacy policy. This is the longer one that you get through when you click to it. And it has to make a consumer aware of a number of things. Now, we were talking about this offline, I hate PowerPoints generally, but I think that in this case and in the webinar setting, I want to make sure you have data. So I'm not going to read you all of these because you can read these for yourself. Oh, somebody just walked in my office. We're good. You can read these for yourself, but you need to make sure that people know what they have. They need to make sure that they know that they're able to opt out. They can request a deletion of their information. They need to know that you won't discriminate against them based on whether or not they opt out. So putting it one way, if they say, I'm going to opt out, you can't change what they're able to access. You can't change what they're able to do just because they said they didn't want to sell you their data or they didn't want you to sell their data. And then you want to have different ways they can contact, they can ask questions, and to the extent that it's necessary, you want to make sure you have policies for different ages and the like. So make sure that you have all of those things, you check the boxes. If this applies to you, make sure you're looking at those regulations so you have a good idea of what the confines are, okay? I've got two more slides here that I want to talk about. I think we're in pretty good shape on time. So one thing is opt-outs. A consumer has every right to opt out if they choose to. If they choose to, the company is required to act as soon as possible, which is to make sure it's done as soon as possible. But in no event may it take more than 15 days. So from a practical standpoint, if you're a smaller business, if you're just getting to 50,000 people, you can probably do that pretty quickly. You don't want to be in a position where you just automatically take the 15 days to take it. Make sure you have processes in place so that way you can act quickly. There must be 2 or more options for making that request. So there can either be a click through, you can say, here's a phone number, here is an email address that you can contact, here's a way you can send snail mail to something to opt out. Whatever it is, you need to make sure that you have ways for people to send that information and to request that they be opted out. You also need to implement systems to make sure that people are able to obtain the requested information. If you go to a website and you click, I want to see the information you're gathering from me, the company needs to provide it. So in this case, if you're the company, you need to be prepared to do so. Now, the timing on that is a little different than the 15 days for the opt-out. You have to acknowledge within 10 days that you've received the request, and then you have 45 days within which to take appropriate action and provide the information. A few more things that were added, and I think were interesting in the latest version, in the mid-June version of the regulations from the AG. We have what's called a just-in-time notification. And they gave an interesting example. I think it's actually smart, right? It's particularly for mobile applications, if there's a purpose that's being used, or if your data is being used for a purpose that the consumer might not expect. So the example that was in the AG's writing on this was if there was, say you have an application for a flashlight, a mobile application on your phone. And when the consumer uses that flashlight, it geolocates and it pings them and it says, oh, now we know where you are. There would have to be a pop-up that says, hey, so you know, this application is figuring out your personal data of where you are. And there'd have to be an affirmative okay or opt out on that. So that's what we call a just-in-time notification. That may apply to 0 of you, but it's something worth noting and I thought it was interesting. And then finally, there can be a notice of financial incentive. So what you can effectively do is choose to buy the data. So you can offset the price of something. You can do something in exchange for the value of the data that's been taken. You have to offer that as something. Based on the number of folks listening right now, I'm not going to go into too much detail on that because statistically, rather unlikely that you're going to fall into that category. If you do, or if that's something you're considering, by all means, let us know, ask the question, and we're happy to talk about it in more detail. Finally, I want to talk for 3 minutes here about implementation to give you an idea of what you do to make this all work, right? First, you probably want someone to do it for you. Again, this isn't an ad for me. It really isn't, because I mean this more from a technical standpoint. You probably want some help in writing the policies, and for what it's worth, we're happy to do that, but there are other people who can as well. But I also mean from the technical standpoint. You're going to be gathering data, securing data, making sure that you keep it appropriately safe. And unless you have a really highly trained IT staff, you may not be prepared to do that. So make sure you have the right tools in place. Even if there's expense associated, the expense probably pales in comparison to what Bron's going to talk to you about in a few minutes. Understand it takes time. So we're already past the witching hour on this, but if you haven't yet, act quickly and know that this isn't something you can snap your fingers and have it work overnight. Make sure you train your employees. The people who are involved in this, they need to know what you're doing. They need to know how to handle it. They need to know that if questions come on, even whether they are the contact information that is listed on the privacy disclosure or they're just getting questions generically, let's make sure that they know how to address those. Let's make sure you're maintaining your records. You got to maintain for at least 24 months, but for what it's worth, probably a best practice to keep for longer, at least for now, until we find a little more round edges on the law, or sharp edges on the law. And then finally, as a segue to what Bron's going to tell us about, ensure that those proper security measures are kept. You need to make sure you're keeping this safe because, as Bron will now tell you, the penalties for failing to do so are quite steep. So I will turn it over to Bron and we will go from there.
All right. So my name is Bron D'Angelo. I am the managing partner of our Los Angeles office, and I handle trials. Now, given with the current situation, we haven't had one for quite a while, since March, but that was my bread and butter, which basically means convincing people not to award a bunch of money against you and your business. If there's one thing that plaintiffs' attorneys like, it is something new, something that they can get their hands on, something that they can make money off of. And with the amount of law schools that we have here in California, I guarantee you there is an attorney out there who's trying to come up with a new and interesting way in order to separate you from the cash that you have worked hard to make. So with the CCPA, there are 2 ways for your business to basically be put out of business for failing to comply with the CCPA. The first is with the Attorney General. We'll go into some penalties with that. And then the private right of action, which I'm going to spend more time on because that's really the one where you're not going to have a lot of room to try and negotiate your way out of something. So with the Attorney General, they have limited resources. They're going to be probably looking for bigger fish. They want to look for the big juicy, multinational corporations that are violating the code. And those are the folks that are going to have, IT people working around the clock in order to make sure they're in compliance with the CCPA. But for those of you who meet the requirements that Ryan went over, and maybe you don't have a huge footprint, you might not get as much from the Attorney General as much that some other folks would. Now, that's certainly not to say that you won't. It's just to say that they may be someone who goes up against the juicy, again, the clients that are really there. They've got the name recognition. So what can the Attorney General do? Well, there's two statutory penalties. The first is up to $2,500 for non-intentional violations and up to $7,500 for intentional violations. So the $2,500 for non-intentional violations and the $7,500, that's per violation. So let's say you maintain a listserv or a database with 50 to 75,000 clients, and they have specific information in there that you're maintaining for whatever reason. That means that for each one of those, in the case of 50,000, that's 50,000 times 2,500 for a non-intentional violation. If you don't have a big business, if you don't have insurance that's going to cover this, it's probably going to wipe most businesses out if you actually are paying for each one of those violations. You know, very rarely when you hear about these big data breaches, is it just one or two specific data points that are being taken. Rather, it's the big, it's all of them, and they're selling them on the black market for, you know, a couple dollars a piece. So you really have to be wary about that, and you really have to take the steps in order to protect yourselves. So non-intentional examples are essentially if you have done your best to comply, but you don't potentially meet the total requirement that the CCPA is setting out. So let's say you just have in that little disclaimer, part of that disclaimer. You don't have everything. You're not making it clear that the individual can opt out of their data being collected. That might be an example of a non-intentional violation. Now, intentional violations, you know, obviously, if you are selling the data yourself, that's certainly one. But more, you know, realistic would be if you've given the opt-out option and you're not taking steps to actually get rid of that data. And maybe, in fact, you're keeping it regardless of whether or not the client has opted out. That's going to be what they're considering as a intentional violation. And even more on the egregious side, if you've done absolutely nothing to try and comply with the CCPA, they're going to consider that an intentional violation as well. Now, the good thing on the Attorney General side is that you're not going to be liable as long as you cure any non-compliance within 30 days of being notified of that non-compliance. That's going to be fine when the non-compliance issue is just, hey, you need a little bit more on your website in order to make it clear that an individual is going to be opt-out, and nothing has occurred. If you have a data breach and your data breach is in part because you have not followed the requirements of the CCPA, that's something that's not going to be able to be cured. And it won't matter the 30 days within being notified, because it's now been done. It's taken care of. The danger is gone. Let's move on to the next slide. So, like I said, you know, that's going to be what the Attorney General is looking for, and you have the statutory violations of that one. But that's not the real danger with the CCPA. The real danger, speaking as a litigator, is going to be on the private right of action. So the private right of action on its face doesn't look like it's going to be as egregious. Basically states that a citizen can bring a private action as an individual or a class, which I'll get more into later, and which is the real danger here, per occurrence. So you still have the intentional and non-intentional violations. But again, on its face, $100 versus $2,500 seems, you know, not so bad. But as I indicated, again, once we get into the class actions, you're going to see where that's really not going to matter much. That doesn't include, however, an individual's actual damages. So, for example, let's say, again, you have a data breach because you haven't followed the requirements, and that individual's data has now been sold. They have had credit cards made out in their name. They have a loan taken out in their name, and they've had to pursue actual damages or actual money in order to get that taken off their record. They are able to recover the cost of those damages pursuant to the CCPA. So, let's say they've had to hire an attorney in order to fight a credit card company or something of that nature in order to get this off their record and prove that the data was never theirs to begin with. That can be thousands and thousands of dollars easily in these situations. And the CCPA allows an individual, again, to pursue that course of action. So under the private right of action, though, there are 3 requirements for a breach to be actionable by a private individual. The first requirement is that the information must be personal information. Now, what is personal information? It's not clearly defined by the CCPA's broad definition, but by California's data breach notification law, which is another statute codified in California Code 1798.81.5. And what that code states is that personal information is a combination of things. It's going to be the person's first and last name or username and password. So that's the first requirement. You've got to keep at least their first and last name or their username and password, plus either a social security number, a driver's license number, a specific account number when we're talking about a financial institution, medical information, or health information. Now, there's a couple more examples that are a little more nuanced, but that's basically it. Think if it's something very personal, then that may be qualifying under that second portion of the combination. Now, what that doesn't mean is if you have their first and last name and their address, that's not something that's going to be actionable because for whatever reason, that hasn't been found to be personal enough underneath that code. But if you're keeping, for whatever reason, again, let's say you maintain a list of customers because you're selling widgets and you've got 50,000 customers, and underneath each sale, you are keeping the customer's name and their credit card number just on file for later. It may be because that's how they want to do it. When I look at have websites and they give you the option of saving the credit card, that's going to count. And if you have enough points there, then it's going to fall under this. So the second way, or the second requirement, is going to be that the information must be non-encrypted and non-redacted. So this is where you want to get the IT people in there to make sure that you are protecting that information. I know very little about computers and saving of data and IT on that end of things, but make sure that if you are collecting any kind of data, it's going to be encrypted and it's not redacted. And then the final requirement is that the breach must have been the result of a business failure to implement and maintain reasonable security procedures and practices appropriate for the information. So the CCPA isn't really good on defining what this means. What is it that's going to be reasonable? And as an attorney, I always hate the word reasonable because that means there's a lot of leeway to argue in a court of law. What's going to be reasonable to one juror may not be reasonable to another juror. And you've got to convince, 9 of the 11 or however many we're going to have after COVID lets us go back. So I don't like the term reasonable, but a good place to start to make sure that you're in compliance is taking a look at the 2016 data breach report that was released by then Attorney General Kamala Harris. So that outlined the standards for essentially what would be considered reasonable in order to protect an individual's specific information. Next. So what are we seeing? So while the CCPA did come into effect on January 1st, 2020, they didn't start enforcing anything until July 1st, 2020. And of course, we're already starting to see the first waves of litigation. And so far, because, partially of the situation with the current pandemic, and because anytime something is new, attorneys are going to try everything under the sun to see what sticks. So we're starting to see 3 types of cases that are being brought under the CCPA, private right of action. So the first one that we're seeing are just individuals by themselves bringing a private right of action as themselves. Most of the people who are bringing this have had their data sold, stolen, or there's more damages than just the potential $100 to $750. You're not going to see a lot of these. You might see more of them in small claims because an attorney is really looking for something that is going to generate the most income for themselves. I wish we could all believe that civil litigation attorneys were altruistic and they were really fighting the good fight to make sure everyone was in compliance. But let's be honest, what they are looking for is enough money to buy themselves a new Porsche. So there's not going to be a lot of private actions for a specific individual because at the end of the day, how much is really going to be recovered in that situation unless somebody has some significant damages there. So the second kind we're seeing, and this one's a little unique, and I don't think that it is going to last very long. I think that judges are going to get, ahead of it relatively quickly. But in LA County, for sure, a lot of the judges are hesitant to kick anything out at the initial pleading stage. And so a lot of times they'll let these things go to try and work themselves out. And that is bootstrapping a CCPA violation with the California Business Code 17200. For those of you who are not familiar, 17200 is basically the unfair business practices code. And the reason attorneys are always trying to file a 17200 violation is because it allows them to recover attorney fees where they would not otherwise be able to. So again, bootstrapping here, it's not really helping the individual bringing the lawsuit. Their damages are still going to be whatever they actually incurred. These are going to be attorney driven. They're going to try and rack up as many fees as possible on this because it allows them to say, hey, I brought this action on the good of the public and, I incurred $200, $300, $400,000 in fees, whatever it is. And they're going to try and recover that. So that's going to increase the individual incentive to bring this action if they end up having any success with it. Next slide. All right, and I'm going to save the last one that we're seeing for a little bit later because I want to go in more depth with it. So what are the defenses against these claims? With the private action, it's pretty cut and dry. The individual bringing the suit has to be a California resident. They can't be out of state suing your company to try and enforce the CCPA. If those reasonable security procedures exist, it's probably going to act as a defense, but you're going to have to prove and convince a judge at the pleadings phase that the security procedures you did implement were in fact reasonable. If not, you're going to depend on those jurors again, and that can not always be the best way to go on something. And then finally, even though most of the time the violation is not going to be curable, i.e. we have a data breach here, plaintiff still has to put you on notice to be able to fix it in 30 days. So, if they don't do that, even if it's an uncurable violation, that's probably going to be a defense as well. Again, you really have to be wary here because as Ryan could tell you at any given day on the employment side, it does not matter how good a case is. If an attorney smells like there might be money at the end of it, they're going to bring that case, and it's going to cost your business money out of pocket in order to defend against it. And if any one of these things actually is successful, I guarantee the next day it's going to be on every single plaintiff's bar listserv and website, and you're going to see a bunch of copycat actions within the next 30 days. All right, next. So now we get to class actions, and this is where the CCPA could be a potential gold mine for individuals. So class action attorneys are the ones that get the big giant awards that you hear about, and it just makes you go nuts. You know, we're talking sometimes in the billions of dollars for an award. And I've got several friends who actually do class actions. They probably spend 90% of their day just trying to find a specific violation that they think that can turn into a successful class to bring a class action. The biggest problem with class actions is that you have to have a definable damage for each individual member of the class. And when you have a situation where each individual may have been damaged to an amount that is not similar, that class is not going to get certified, and the judge is going to say, well, you're going to have to bring that as an individual action. But what the CCPA does is it gives class action attorneys an automatic way to find damages. You have the $100 per breach in the unintentional and the $750 per class member in the intentional damages. And so right away, they have a built-in mechanism to certify their class, and that's all they want. So if you get an attorney who all of a sudden finds out that you have a data breach, they're going to be on the phone calling each and every one of those individuals that they can find. They're going to be putting out, you know, ads on Craigslists, on the daily news shows, on wherever these guys try and find somebody who's just kind of sitting at home all day, not really doing anything. And before you know it, they're going to have a class of, you know, 10,000 people that they're going to bring. So the part about class actions that's so bad, if you don't know, is that it allows for attorney's fees as well. And in most of these situations, it's not just one attorney working on it, it's dozens sometimes. And so those fees ramp up really, really quick. Just an example, if we go back real quick to the other slide, just data breaches from 2014 to 2016, if that was allowed to have the statutory CCPA actions for private individuals, would have resulted in approximately $37.5 billion in individual fees. You know, if you don't think $37.5 billion is going to get some attorneys excited, I don't know what to tell you. I got some oceanfront property in Arizona to sell you. So let's move on. All right, so what kind of types of class actions are there out there? We've got two. The first being very, you know, straightforward, cut and dry. Cases alleging actual data breaches. Again, you've got a data breach. You know, we've all heard about them. I think what was it, a couple of years ago, the Equifax, where just millions and millions of people had their information taken. These are specifically allowed by the CCPA. They are very straightforward. That class is built in. Now, what's a little more interesting, and we'll see if this catches any scope here, is cases that are alleging a failure to comply with the procedural requirement. So in this situation, think you've got a website, you meet all the requirements of everything else, and you don't have the opt-out information at the bottom of your website. Then in theory, each of the individuals who goes to your website could be a potential member of a class because they have visited. Theoretically, you have taken their data and they were not presented with a procedural way of opting out of that section. So, you know, either one of these, again, when we're talking about millions and millions of dollars in potential fees and awards, are going to be business killers. I don't know of very many businesses who are going to be able to survive that kind of hit that we're talking about here. So, moving on. So what is it that your business can do? So first and foremost, encrypt your data and implement reasonable security measures. You want to make sure that you are complying at the outset. Because again, if you've done that, if your measures are reasonable, that should act as a bar to any litigation against you. Number two, if it is a curable issue, meaning that damages haven't already occurred, there's a breach situation, it's just a procedural kind of issue, make sure that if you get notice, fix it immediately. You have that window for a reason. I know there's a lot of people with businesses that wish the ADA violations had that kind of window so they could fix those procedures instead of getting sued, but we're not there yet. And then finally, if you don't need to save the data, don't. There are very few situations where you're going to need both a client's name, their health information, social security number, health data, anything like that. You know, the one I can see again being more ubiquitous is going to be the name and the credit card information. If there's not a reason for you to have that on your website, just don't have it. It's so much easier for you to just not have the information instead of maintaining it and keeping it and potentially opening up yourself to a lawsuit. So with that, I think we've got any questions. We've got a little bit of time left.
If you have any questions, go ahead and unmute yourself and you can ask the question.
I would say one of the last times we did this, one of the questions had come in, since every webinar now has to have a COVID-19 thread to it. People had asked about maintaining health data of those individuals that come onto their premises, whether we're talking about, you know, temperature or their names or whatever it is like that. But that's technically health information. And we're in a situation where, okay, well, you know, if the state government is requiring that, and then we have the CCPA, well, where does it come into place? And I've thought a lot about that since that question was asked. And really, I think the best situation there is to, you know, again, minimize that data. You don't necessarily have to keep their health information. You may just say, look, you know, we have this individual and, you know, they didn't meet the certain requirement. You don't have to tell them what it was, if it was a fever or temperature or whatever. You know, just keep it as simple as possible. All right.
I have a question.
Oh, here we go.
I have a question. This is Brett from the chamber. When Ryan started, he said the very first criteria was that this was aimed at for-profit companies. So nonprofit companies that gather, you know, thousands upon thousands of email addresses to, you know, in their database just to communicate with people and stuff. This isn't the type of thing that they have to be worried about. Is that accurate?
No. And I'll take this one only because my wife actually works for a nonprofit and they have a database and a listserv of something like 200,000 people. They have to comply with the CCPA as well. Now, the Attorney General isn't necessarily going to be coming after a nonprofit as much, but that doesn't mean that an attorney won't. But in that situation, again, it's what data do you really need to keep? You know, in their situation, they're not really maintaining that second tier of info. They're not maintaining the social security number or health information or credit card number. So for a nonprofit, and again, I don't work in the nonprofit arena, but there really shouldn't be a situation where you would need to have that data stored. I can certainly see a name, an address, and a telephone number. That is not going to make you have to require with the CCPA, because that's not, that's not going to expose you to a lawsuit, because it doesn't meet that second criteria of information.
And as a best practice, in any situation in which you are capturing data, you want to be careful with it because there can be other downstream ramifications. So I think in any situation, for example, if you don't qualify for any reason, but you're close or what, you want to be wary because there still can be issues that arise with data or the failure to keep data as it should be and breaches and all of that, anywhere from pure negligence type things. So every organization should be aware of these, whether or not you specifically apply. Still keep in mind the focus that is being placed, frankly, worldwide on the protection of individuals' privacy data.
Thank you.
Oh, weird.
Oh, Kathy, I think you're muted.
I want to thank both of you, Ryan and Ron, for being here today. And also I want to thank Pettit Cone for sending both of you. It's really great information and we really appreciate this. Thank you.
Our pleasure.
Thanks for having us.
All right. Thank you all.